Louisiana State Penitentiary sits on 18,000 acres of land that was once a slave plantation known as Angola, after the African country from which enslaved people were taken. Today, men who are predominantly black are forced into those same fields to plant and harvest by hand. They do so under the watch of an armed guard and an overseer known as a pusher, whose job is to make sure the men work with, quote, reasonable speed and efficiency. For this, our clients earn between 0 and 4 cents an hour.
So that was Samantha Pourciau, a senior attorney at the Promise of Justice Initiative, describing farmland work at Angola during a press conference last week. She was the lead counsel representing the people incarcerated at Angola that were suing the former warden and the Louisiana Department of Public Safety and Correction. Whether or not the farmland work is constitutional had been on trial over the past few years. But last week, a federal judge ruled that this work could continue.
In yesterday's ruling, the federal district court confirmed what our clients have known in their bodies and in their bones for years, that the conditions on Angola's farmland are unconstitutional.
However, because of a recent Fifth Circuit ruling, the court believes that its hands are tied. The court said, but for the Fifth Circuit's ruling, it would have found in favor of our plaintiffs.
Both Pourciau and Samantha Kennedy acknowledged that the trial helped to bring about some even temporary relief for the people at Angola who were working on the farm line, but they're not sure the relief is permanent. Here's Pourciau one more time.
Despite acknowledging these constitutional violations, the court declined to order permanent relief. That means the protections won through the 3 years of hard-fought litigation, breaks, shade, accommodations for the most vulnerable to heat, can be rolled back by the Louisiana Department of Corrections at any time.
Now, both Pourciau and Kennedy were critical that the judge did not mention what they described as a central claim to their case, that the farmland work caused dignitary harm to people through making them reenact a form of chattel slavery.
Incredibly, the court only ruled on the heat claims and never once mentioned the legal issues covering slavery, psychological harm, or dignitary harm that people endure while working the farmland. The court was simply silent.
And because this is happening at a time where people are describing voting rights as under attack, redistricting is going on in Louisiana, Kennedy described the persistence of farmland work as something bigger. Here she is.
With the destruction of voting rights under Calais versus Louisiana, an aggressive state-level assault on black political power, Louisiana sits at the center of the country's neo-Confederate political project.
Now, the Louisiana Department of Corrections describes farmland work completely differently. They describe it as a form of valuable work that serves an important purpose, including harvesting fresh vegetables for inmate consumption. When I spoke with the Department of Corrections, they also said they were committed to operating safe and lawful correctional programs. If you want to learn more about this case, you can go to veritenews.org. There are 2 stories that you can find, one written in February and another written at the end of May, that both talk about the case and the people involved in it.